I'm hoping I can get this to run. Let's look at some of our worker protection statutes. And So for some reason I've given ONSOL credit on the copyright here. But we can see that these, I'm recording this March 2 of 2017. The slides are a little bit old, but this law it's always in flux, but it's not dead so far. The first thing we might want to look at is workers' compensation acts. And to do that, to do it somewhat justice, at least with the first act, we have two federal acts. The Federal Employers Liability Act, commonly known as FELA, or the Jones Act. FELA protected workers in the business of interstate commerce by rail. So, a railroad that really only operated inside of one state may or may not be covered by this. But if they connect to another railroad that does, it's pretty likely they do. The only ones that are really don't apply to this are manufacturing facilities might have their own railroad. For instance, the brewery here in St. Louis has its own railroad, but it is not covered by FELA. The workers there are covered under the Missouri State Act. And the way they do this is that a railroad operates only within the confines of the factory. And so what they'll do is they actually have a yard that the locomotives never exit this yard. They put the cars out and the UP or the BNSF or whoever comes in grabs it. But definitely workers on the BNSF, the Union Pacific, the CSX, the Norfolk Southern, the Kansas City Southern, the Canadian National, and the Canadian Pacific, as well as the CSX, are covered by this. And it's a federal law. And because it's federal law, under the Supremacy Clause, Article 6, Constitution of the United States of America, it is supreme. It's a little different than what we think of as ordinarily workers' compensation, because we actually have the worker has to show proof of negligence on the part of the employer, and that negligence was the proximate cause of the employee's injuries. Same thing happens in the Jones Act. That tends to be, Jones Act tends to focus on the seaworthiness of the vessel. So things like the fact that you got tossed around, and that caused you to come out of your bunk, is generally compensable. If you were doing some things that contribute to it, you're going to be under the comparative negligence standard, so they're going to look at your behavior too. The interesting component here is we're in broad tort damages. So it's real open pain and suffering, real payment of medical. Under both systems, it tends to be that the employer has already paid your medical. Under the Jones Act, seamen are entitled to what's called maintenance and cure. It's a very old system where, and it takes care of people who get hurt on a ship and maybe they've got to leave you in Manila. Well, guess what? The ship owner is the one who's responsible to pay your bills. It sort of makes sure that the hospital or whoever's providing the care doesn't get stiffed. It's an interesting, so all of this comes out of the theory that if we look at what Jay Gould and some of the other robber barons did, if you got hurt at work, they would just throw you to the side, essentially, say, find your own way back. They're very similar, as I've said before, to Elizabeth and her treatment of common soldiers in wars. She would abandon the war, bring her royals back, and leave the common soldier to find their own way home. That doesn't really compensate. We need to put the cost of goods sold needs to also include the cost in the blood of the worker. And so what we're getting to here is we're going to kind of statutorily force this upon employers. Tort damages is better generally from a damages standpoint than what we get under the state workers' compensation acts. What happens in the State Workers' Compensation Act, from its broad perspective, is you got hurt on the job, employer owes you X, all right? What a lot of them use is what's a meat chart. You know, I hurt my left thumb, well, my dominant hand is my right thumb, so I only get 5% of the hand as a whole, or something like that. A thumb is probably 10%. So I get a certain monetary award for the actual injury, and anytime I'm off duty, I get compensated at about 60% of full wage, based on what they calculate as my average weekly wage. And this varies. This is all state stuff. And a lot of this state stuff came in at or about the Depression. And so it's been tinkered with over the years, but a lot of this is pretty old. Oddly, or maybe not oddly, a lot of the employers petitioned this. It's sort of, you know, as I peel behind the veiled curtain of the Affordable Care Act, the insurance companies and some of the major employers had a lot to do with how do we phrase the general statement. And I think businesses always have to be aware that we can actually get the ear of congressmen, the ear of legislators, and maybe we can draft our own legislation that they can then take in and debate. The same thing sort of applies in states' workers' compensation, that we get to get medical treatment paid by the employer. My experience for injured employees is a lot of times the physicians hired for that employee is what I call the greenback poultice doctor, who is convinced that there's nothing wrong with you that a greenback poultice, that is, throw some money at this worker, won't cure. To take the employer's side of it, some people take a hangnail and want to make it into a blown disc in the lower back. You know, there's always tug and pull here. I represented a lot of injured workers, and a fair number of them were all about how long can I stay out on this, how big an award, I've got to make my, you know, it was all about the money. It wasn't necessarily about, hey, get me back to work. You're also, under workers' comp acts, entitled to a permanency award, but almost all of this is based on average weekly wage. If we go back up into this tort damages area, juries get to fix this. In a workers' compensation act, it's usually awarded by an arbitrator who's going to look at past cases that are similar. It is worthwhile to mention that under all these acts, any retaliation against the worker, such as willfully removing their job or kind of getting rid of them in any fashion, can lead to a separate lawsuit. You know, if they come back from work and we're not really fully accommodating them, trying to get them back in, you know, there are people who retaliate against workers who get hurt. So if somebody's got a workers' compensation claim, even if they deserve to be fired, and I'm going to make this public, wait, you know, let them run this system completely through, let the period of appeal disappear, you know, be careful, read the retaliation statute, work with your people. If you fire them for the reason of, hey, they fired this lawsuit, you're in trouble. It doesn't matter how long you wait. You know, there's some real teeth in these retaliation statutes, and I've seen some pretty big awards. So, you know, think of these workers' compensation acts as in many ways favoring the employer, because they give you a system in which you can litigate consistently, and it's fairly predictable. So it can be really valuable. You can kind of put your money on it. Let me make a final comment on insurance. My experience is much more FELA, but generally the railroads that are covered by that kind of know in advance how much money each district costs them. On states' workers' compensation, generally you can insure workers' compensation losses, and I think you should if you've got a relatively hazardous industry. And what the insurance companies will ordinarily charge you is we'll take last year's claims, so it's 1.2% times last year's claims, this year's premium. What they're essentially doing is saying it costs us about 20% of claim to process all of this. And the nice thing for an employer is I don't have to be an expert on the difference between medial collateral ligament damage and an anterior collateral ligament damage. I can tell you, speaking from sort of lawyerly treatment, depositions and everything else, there's a substantial difference in the treatment and the pain and the suffering and everything else, but I wouldn't expect the average widget manufacturer to necessarily know that or want to get too embroiled in it. This is a system where we can maybe kind of say, hey, the insurance company makes those decisions. We're in the business of making widgets. We don't want to be on the wrong side of the table with you. We want you back as a worker. All right, so let's keep moving. Around 1972, we got to the Occupational Safety and Health Administration was formed. Interesting that a lot of this litigation, or a lot of this legislation, comes in the middle of the next Nixon administration. ERISA, E-R-I-S-A, which is the Employee Retirement Income Security Act, is a 73 creation. And what we're trying to do in occupational safety and health is actually sort of normalize the workplace, that if I work at McDonald's, I'm going to expect kind of the same code at Arby's. And it is national, but the problem might be that if we let the states have all of this, there's always a race to the bottom. So if we're going to, again, point out maybe like that the right to work legislation is a drive by each of the local states to lessen workers' rights, sometimes we're going to attract business by going, hey, we don't have the regulatory burdens that Alabama does. Well, come on over here to Mississippi and, all bets are off and blah, blah, blah. Well, from a broad public policy standpoint, we're generally better off with kind of, let's have a sort of uniform system of rules and regulations. And if you read the OSHA rules and regulations, and I believe they're entitled 28, I always get 28 and 26 confused. 28 is the IRS, I'm pretty sure, and 26 is labor. They're pretty reasonable, and they've been worked out in a framework with businesses. For instance, one that pops to my mind was a regulation on the height and tread depth of stairs. Well, it only applies to stairs where you have more than 3 in a row. They're kind of saying that if you've only got 2 stairs, maybe that's not enough of a pattern. People can, that's not that dangerous. Once you get to 3, we're in a new setting. So, expect treadwear rules. How wide can the stair be? How high must the stair be? Do you need a rail? Do you not need a rail? All this kind of stuff. And so the OSHA promulgates the rules, issues regulations, asks for public comment ordinarily. And so it really works relatively well, I think. For workers and others, we have to recognize as employers that OSHA has pretty broad jurisdiction. They may just do a spot inspection. It's the same thing as the meat inspector showing up if we're a restaurant. It's the same thing as immigration control and enforcement, ICE coming in, checking for green cards or whatever. Do OSHA and others need to give notice? The real answer is no. As a courtesy, they oftentimes do, but sometimes they're going to do a surprise inspection, because we all know if you get a call on Friday saying we're coming with an inspector on Tuesday, that employer might hire a crew to walk through and get everything going. Employees can always turn in anonymous tips. OSHA, Department of Health or Labor looks at, do we need an inspection here or do we not? They tend to go in and do them. One thing I would say, if you're going to sit there and ask for a warrant every time, you may get an inspector who's not willing to give you much time to remedy the situation. Ordinarily, what the inspectors want is they want you compliant. If you really think about it, that's probably best for your business anyway. Being OSHA compliant isn't that challenging and shouldn't be looked upon as tremendously burdensome. Not to say, now that's a general statement, not to say there aren't some places where we get to some area overreach by OSHA, but OSHA is a pretty well-oiled machine in my estimation. It hears labor and it hears management. I'm not sure what FLA stands for. I think it's federal. Pardon me. I don't know what FLA stands for. I just had it in my brain and now it's moving away from me. When I glanced at these, I thought, I know that's the federal, that's the, I think it's the Federal Fair Labor Standards Act. That's what it is, Fair Labor Standard Acts. Again, we're going to be in a limited area. Remember, when we look at the Congress, when it's passing laws, it has to have a power under Article 1, Section 8. Boom, there it is. Interstate commerce and maybe production of goods. That, if we look at goods, that's going to get us closer to interstate commerce, because in the United States, we're probably going to make it in Michigan and sell it down in Georgia, or sell it off in Cuba or whatever. So some of this stuff we're going to look at in here, child labor. You've got to be at least 16. There are limits. You can bring in people younger. Farms are almost always exempted. But we've slowly inched, I know people who tell me, hey, my cousin was driving an over-the-road tractor when he was 10 years old. Now, we're not talking farm tractor, folks. We're talking 18-wheeler. They just stack that kid up on pillows and put a wood block on the accelerator and the brake, and boom, this kid would be hauling cattle off to the slaughter yard. Anyway, one of the areas we go to is here's where we get the federal minimum wage. Love to have a long discussion about minimum wage, but let's leave that to the economists for right now. Overtime pay, the 40-hour work week. I talked in a previous video about the great Frances Perkins. She put a lot of this stuff in place, and it's still there. All right? One of the things we're always going to look at is, how do we know whether we're on the clock or off the clock? Well, let me make a couple of points. If you're commuting to and from work, you are off the clock. And so any injury that occurs there, workers' comp's not going to help you. None of the minimum wage or anything like that is going to help you. There's no door-to-door coverage. We don't calculate commuting time as part of the work. But if when you get to the property, and walking in from the parking lot, now you're still commuting. I think what we find is that there's a space where that punch-in clock is right inside the door. As soon as you come inside the door, you clock in, you're on. There have been some efforts by employers to go, well, we don't have them clock in till they put on all their protective gear. This has been litigated, and if it's a real component of the job, here's how it is, employers. You pretty much have to treat that as compensated time, okay? You know, but at the same time, walking in from or out to a bus stop may or may not be. You know, if this bus stop is the way of, it's kind of the only way we can get our workers in here, you may find that they're actually on the clock as soon as that bus stops. You know, so a good employer may add time for the time they go in. Here's FMLA, Federal Family Medical Leave Act. And this is a major act under federal law. Now, we have a lot of misconceptions that come into play here. Let's begin with, again, here we go. This is something we see in ERISA and a lot of other statutes. It's companies with more than 50 employees. I may be wrong in this, but I think the Affordable Care Act goes all the way down to 30 employees. If you have 30 or more employees, boom, you're in it. That one's kind of a major shift. 50 is tended to hold up well in the courts. That's big enough that we can say that, yeah, that actually is probably an interstate commerce type of shop. Eligibility. This is very similar to ERISA. You've worked there for 1 year, and you worked 1,250 countable hours in a prior year. Now, if you want to have a beautiful time, read the legislation on how do you calculate 12 hours in the prior year. Does overtime come in? You know, generally, yes. But, you know, it may or may not. You know, one of the things we find in all of these acts, ACA, which I don't believe I've got covered in here because no, it was in play. So hopefully it's in here. One of the things employers do a lot of times is they're going to limit it so they don't, you hit 1,200 hours, that's it, you're not working for us anymore this year. They're going to play that game, and they're free to. You know, there's no anti-discrimination here. It's no, we're not paying that benefit. Another reason why sometimes unions come in. You've got to guarantee all our workers, here's a minimum. Every worker that you hire will get 1,400 hours or 1,500 hours. They'll get it whether they work it or not. That's the only way we can keep you supplied with an adequate workforce. So, you know, some seasonal employers are always going to gripe about this. I believe, but a lot of seasonals, they're going to fall in below this level because if I remember right, full-time is absolute full-time is around 2,100 hours or more like 1,800 hours. So this is kind of looking at three-quarter time employees. And if we think about that from where should Congress reach? You know, if I'm working 3/4 of a year for you, I probably need to be treated as though I'm working all year, if that makes any sense to you. Otherwise, you know, maybe this sounds like baseball players. In the old days, baseball players actually had winter jobs. They weren't paid so much money. They would actually go sell insurance in the off or dig ditches or whatever. Only as it became a really big business in the late 40s and 50s did some of the change come. I guess actually had a lot going on in the 20s and 30s too. Now, here are the things that a lot of people think, boy, this is a birthright. This is a statute, and a lot of people want to expand it. They want pay here too. You don't get pay. Under this act, you get 12 weeks leave. under these circumstances. All right, birth of a child, adoption, or foster care. You go get a kid, or you have a kid brought in on foster care. It's to give at least one of the spouses, and I said at least, please emphasize that, um, that we get to transition or be able to, so that we get that bonding, that very important bonding with the early child. Both parents are available to take this. Notice you can also get this for a serious health condition. I get diagnosed with cancer. I really can't work. I really need this. Or I've got a diabetic condition that causes some kind of deal. You may or may not get full leave. You've also got the right to get this leave if you're tending a spouse, a child, or a parent with a serious health condition. So, some people take advantage of this. There has been some abuse, but, what are the teeth against abuse? There is some availability there. Definitely check the regulations on this. But this is why I think we're not necessarily going to get paid leave in the United States, because this is a compromise. It's hard for us to have a going business if, we've got a lady who's on maternity leave every 2 years and taking 12 weeks out. Who do we hire to replace that individual? It's a long process to hire people nowadays, particularly skilled, or, some of us are irreplaceable, at least momentarily. You are guaranteed a return to same or equivalent job with same or equivalent benefits. Doesn't mean you get the same job back. You may be in a slightly start over position. Somebody else, because of this, hey, we had to move somebody else up the ladder, and we can't just move them back down. You've got to recognize, employee, this is not an unlimited right to use this, and you've got to be a little careful in the modern workplace to think that these are perfect benefits. This is a federally created statute. It does, as with any other statute, have exemptions and loopholes and trade-offs. So it's not going to be perfect from the employer's or the employee's standpoint. And here are some other benefits. COBRA. This one is kind of disappearing a little with the ACA. It's something that Bill Clay claimed he got it through. I believe it's Congressional Omnibus Budget Reconciliation Act of 1986. But what you get is, if you were employed somewhere and you lose that job, you have the right to continue medical coverage if you pay the premium. Now, I would caution you that the insurance company can charge you up to, I believe, 110% of what it was charging your employer. So it doesn't necessarily mean you get your insurance coverage cheap. But the beautiful thing is, you may be able to get some insurance coverage going, which would let you bridge over, particularly on a pre-existing condition. And I believe you get this for 18 months. So it has some benefit. A lot of people get COBRA. A lot of the guys I work for on the railroad said, I don't want it. It's way too expensive. I just, it's not a better deal. I can get a better deal in the private market. With the Affordable Care Act, I'm not sure where we stand there. The repeal and replace, that's a big football. My gut feeling as I talk here in March is we may not have this passed until August of 18. And even then, it's a hot button issue, because, if the Republican Congress and the president don't do a good enough job, they can really put themselves at risk, because there are some very popular features in the Affordable Care Act, and if they get rid of them, we're going to get that out. So I believe it's an 18-month. It may be as much as 2 years and a month. I'm not dead positive. I've spoken various times about ERISA, Employment Retirement Income Security Act, which I spell out there. I didn't think I did. It helped create the IRA, the Individual Retirement Act. It's something we still find about half of all workers have no retirement plan in place at work. So this is an Individual Retirement Act. Right now, the limits on are $5,000 a year. No, they're more than that. They're $5,500 a year per employee on earned income. You've also got the right to contribute for a spouse, even though the spouse doesn't have earned income, so that a married couple can put away $5,500 a year. If either of them is over 50 years old, there's a catch-up provision that permits $1,000 a year as I dictate this. Both numbers are finally, this is something that happened in the Bush administration around 2006. We tied everything to inflation. And so there's a federal inflation indicator. It's also used under Social Security that sort of automatically raises these limits as cost of living goes up. So it's kind of a built-in COLA, cost of living adjustment. And these amounts we can put in will keep ratcheting up. Will Congress ever come in and set hard limits? Yeah, I would say yes, because they've done that in the past. But if you look at the charts on this, you start putting $11,000 a year away when you're 18. Okay, I know it's not going to happen. If you're still living with mom and dad and they support you on it, maybe, you put that away for 10 years and let it ride and can get 10.52%, which is kind of a long-term S&P 500 index return, you can retire with a lot of money. We looked at, I think, a total of putting $72,000 away. No, it was more than that. It was $64,000, I think. At 10.5% under the rule of 72, and I've got a video if you want to go look at that talks about the rule of 72. If you put 10 grand away, that's what it is. Put 10 grand away, wait 50 years, have it invested at 10.5%. It will double 7 times. 10 times 2 to the 7th is $1.28 million. So that first 10,000 you put away can really add up. Same kind of thing is happening in the 401k. I teach a long course on retirement planning at UMSL. I love the way I teach it. It may not be for everybody. You've got to be able to teach yourself. But it essentially ended the DBP, the defined benefit plan, the old pension plan. I don't want to go into it too far. It's a course unto itself, but I think we need to know that the 401k and all the matching provisions and all the investment stuff is part of ERISA. And so if you're going to offer a retirement plan, you're going to be in ERISA, and there's a lot of regulation. There's a lot of playback. Department of Labor oversees it, even though Treasury, the IRS, is supposed to. The IRS says, we both have jurisdiction. We're going to let labor take it. We do have unemployment compensation. Here's another diatribe potentially. During the latest economic crisis of 2008 through around 2011, we gave people, that was a lot, we kept extending 24 weeks of unemployment benefits. I may be wrong in this, but I think some people got 2.5 years they didn't have to work. There was a tremendous amount of waste there. And it was paraded around that $1 of government benefit paid to you as a wage for not working really benefits the economy at $1.72. I don't know what they were smoking, folks, but that's absurd. this is some kind of multiplier. And, oh, yeah, no, it's good. Yeah, right. It just, it added to the debt. I'm not a buyer on that one, okay? A dollar paid out has a dollar of economic benefit. And it probably could have less because you get taxed on it. Now, is unemployment compensation taxable? That I'm not dead positive on. It's administered by the states. The states all have different unemployment compensation laws. It's kind of like Medicaid. The federal government basically does sort of block grants, but the states are responsible for administering it and also funding it. Another thing we need to talk about, and I probably didn't give it enough time, is Social Security or FICA. First of all, we get taxed at about 13.5%. It's 6.85% on the employer side and 6.85% on the employee side. If you're your own boss, you pay 12.8% total. You pay both sides of FICA. And I can't remember what FICA stands for. Included in FICA is Medicare, which no longer has a limit. Social Security, you only pay up, I believe, through the first 110,000 of income, and then you stop. The reason you don't pay above that is that Social Security doesn't really provide a benefit. It has kind of a sliding scale. The more you make, kind of the less your benefit over time, because it's really designed to replace about 80% of all end pay at or near the kind of poverty level, or the $38,000 thereabouts. If you're making about $40,000 a year, expect that you might make about $32,000 in Social Security at retirement, if that's your lifetime of pay. If you're at $100,000, expect that you may get about $50,000 or something like that. You're going to get a lot lower benefit. It kind of slides off, and so anybody making $250,000 a year has to save for themselves. They've got to get into this 401k, because the 80% number seems to be magical in retirement planning. If you can get enough savings where you do about a 4% withdrawal, stay invested in the market at least substantially, 60%, 40% or more in the market throughout your retirement life, you probably can retire fairly comfortably. Because if you're sitting there with an 8% portfolio, you're pulling out 4%. Well, after fees and expenses, you're growing it at 3.5%. And ordinarily inflation is around 3%. Perfect system? No. But you're no longer working. And I can tell you, as you get older, it's harder to get in and show up. So is Social Security going away? Probably not. Too many people rely on it. Too many people have paid into it. It is, if you look at voter participation, guess who votes? The elderly. Do young people vote? No. So a lot of these laws don't benefit the young. They benefit the old. And the old, of course, show up to vote them. So Congress is not getting rid of this. They may modify it. They may privatize bits of it. But even that, there doesn't seem to be a lot of drive that way. Bush made a big, strong play, and I thought a well-reasoned one, to let's at least privatize some of it. Let's let people pay the minimum to pay benefits to everybody, but then let them take some of their own money and invest it as they want. I tend to agree with Bush on this. I ran on it, as one of my polls in my little foray into the congressional race. But, we eventually pay in, and this is where we get our Medicare money. Medicare has got some real problems with it because it doesn't have sufficient payment checks and balances. It's likely to be modified over the years. But since it's been put in 63, 64, people kind of like it. Doctors and hospitals somewhat like it because at least they're getting paid. And we do have, with an aging population, a lot of the usage of the healthcare system is people that are pretty old. Young, healthy people don't need to go to the doctor that much. So, not quick and dirty, but that covers most of what we've got to study in this topic. Y'all have a good day. I'm going to maybe get one more done today.